Thank you very much. And I would also like to thank the organizers for organizing this beautiful event and taking us to Brno, and thank you for this opportunity to visit Brno and your lovely faculty. I must just stress out that I'm not speaking in my capacity as a justice of the Constitutional Court, and my views are not of the Constitutional Court. I'm speaking as a researcher and a university professor. I would like you to link my presentation regarding the different approaches of my Constitutional Court when interpreting the role and scope of EU law and the Convention in Croatian constitutional context with the notions of sovereignty, with notion of national identity, and most importantly, the notion of constitutional identity, because those are the three main values that are reflected throughout my presentation. So when we talk about the EU law, acquis, and the Convention, they are, of course, two supranational legal orders which are included very strongly in the case law of the Constitutional Court of the Republic of Croatia, as it is bound to do so by the Constitution. So we have the Council of Europe's Convention, and we have the EU law, or the acquis communautaire. The Convention, as an international agreement, it was ratified according to the Constitution, and so it became a part of Croatia's internal legal order, but with higher legal power than domestic laws. And this is one part of the issue. The second issue is the acquis communautaire, and I must stress out that Croatia's path to the EU was lengthy, and during it we needed to amend the Constitution accordingly, and we had to, of course, change our legal system significantly. However, when the Constitutional Court interprets these two legal orders, or these two supranational legal orders, the interpretation is significantly different. Before I go to the detail, I want to show by example what I mean when I say that the Constitutional Court interprets these two supranational legal orders differently when determining their importance and legal standing, which is very important. So the Constitutional Court expressed its view on the strength of the legal standing of the Convention and of the European law, or the acquis communautaire. First of all, when we look at the constitutional setup, we will see that their legal standing is regulated by two different constitutional provisions. The legal standing of the Convention is, as an international agreement, is determined by Article 134 of the Constitution, under which all international agreements which are ratified accordingly to the Constitution become part of the Croatia's internal legal order, but with higher legal standing than the Croatian laws. On the other hand, we added Article 141c to the Constitution, and this aligns the scope of EU law, or the acquis communautaire, which we inserted, as I said, as a preparation for our accession to the European Union. And this article stipulates the position of EU law with regard to the Constitution, to the Croatian legal order, and the obligatory use and protection of rights and which arise under the acquis, and the obligation of courts, state bodies of local and regional self-government, and legal persons vested with public authority to apply union law directly. So this is the constitutional setup under which it is clear that the Convention under the Constitution is an international agreement, but became an inner part of Croatian legal order with higher legal standing with in connection with Croatian laws, and that the Constitution elevated the position of the European law, or the acquis communautaire. However, when we look at the Constitutional Court's case law, I will use two decisions which are very striking. You can see them on the slide. And although it would seem from my prior statements that EU law has constitutionally higher standing, that doesn't follow from the Constitutional Court's practice. Namely, as early as in 1998, Constitutional Court of the Republic of Croatia for the first time established the incompatibility of a national law with an international treaty. This was the first step. Then the second step, 2 years later, in the decision you see on the slide, which issued in the procedure for the abstract review of the constitutionality of the Expropriation Act, the Constitutional Court of the Republic of Croatia for the first time assessed the conformity of a domestic law directly with the Convention, rather than with the Constitution, and repealed some provisions, finding that they were not in accordance with Article 6 of the Convention. In that decision, the Constitutional Court of the Republic of Croatia took the position that any incompatibility of any national law with the Convention also means that that law is incompatible with the rule of law, principle of constitutionality and legality, and the principle of legal monism. In this way, the Constitutional Court of the Republic of Croatia effectively replaced the assessment of the constitutionality of a law with the assessment of the conformity of a domestic law with the Convention, thereby securing a quasi-constitutional position for the Convention within the domestic legal order. On the other hand, as you can see in 2015, the Constitutional Court firmly stated that EU law is below the Constitution with regard to legal force. I will come back to this decision later because it is very weak in argumentation and there are a lot of missing points to elaborate, which the Constitutional Court did not do since 2015, and it did not find reason to elaborate on this stand. So in short, the actual quasi-constitutional position of the Convention, the Croatian legal order, is primarily the result of the specific approach of our Constitutional Court to the Convention and its understanding of the obligations arising from Croatia from the Convention. Starting from the concept of legal monism and the constitutional requirement for the direct application of the Convention, this approach of the Constitutional Court of the Republic of Croatia contains the following positions. So these 4 very important prerequisites that the court stated they are given and cannot be changed. So the first is that national constitutional courts and the European Court perform similar tasks, but only at different level. The second one is that Article 1 of the Convention, as the normative framework for the key principles of the entire Convention system and the principle of subsidiarity, is the most important for determining the obligation Croatia has. Third, European Court judgments go beyond the boundaries of an individual case, and that the Convention is a constitutional instrument of European public order, so the European Court creates European constitutional standards. So from this, it is really obvious that the Constitutional Court finds that the Convention is on equal footing with the Constitution. Of course, there can be problems because this view is acceptable when there are no collisions within the two. But of course, if such a collision would occur, it would be difficult to solve such an antinomy of norms. It is now necessary to put things into context in order to be able to explain why the Constitutional Court has this rather unique opinion on regarding the Convention. So we have to travel back in time to see the importance of the Convention to Croatia as a state and to our legal system. Namely, as Croatia, as you all know, became an independent state in 1991 and it was internationally recognized in January 1992, the new state badly wanted to belong, so to say, to enter all possible international organizations in order to further its chances for success in the goal of independence. Council of Europe was one of such international organizations. We wanted very badly to be a member of. As you all know, in order to be a member of the Council of Europe, we have to ratify the Convention. And we wanted to. But the Council of Europe did not want to admit us because of certain problems regarding the rights of minorities and so on. And we were allowed entry only in 1997. Even then, in a lot of political and legal conditions. Croatia was under monitoring of the Council of Europe until September 2000. To see the importance of the convention in the case law of the Constitutional Court, one must mention one earlier decision of the Constitutional Court from 1993, in which the court invoked the right to effective legal remedy, although the Constitution did not contain such right, and the convention was not a part of Croatia's legal order, nor was Croatia bounded by it. However, we, as a state, bound itself to the convention as early as 1991 by its constitutional law on human rights and freedoms and rights of national and ethnic minorities. This goes to prove that the Constitutional Court was always, one could almost say, enchanted by the convention, and this is probably the reason why it gave the convention such a high legal standing within Croatia's legal order, although it is constitutionally clearly lower. Of course, one must highlight also the political reasoning behind this, as it was important to show that the new state abides all standards in human protection, especially minority rights. However, when examining the legal standing of EU law, Article 141c of the Constitution seems rather clear. It explicitly stipulates that Croatian courts shall protect subjective rights based on the EU acquis, and that the exercise of rights arising from the EU acquis is equated with the exercise of rights guaranteed by the Croatian legal order. In this way, the Constitution places before Croatian courts the obligation to interpret domestic legislation in accordance with EU legislation. The constitutional obligation of harmonized interpretation also encompasses guarantees of the protection of fundamental rights and freedoms. When applying national law, ordinary courts have a duty to ensure that it is applied in a manner that does not prejudice the effective and uniform application of EU law. In the event that national law they are required to apply cannot be interpreted in a manner that is consistent with the requirements arising from the relevant provisions of EU law, national courts are required to respect the fundamental principles of EU law, legal order, such as principles of direct applicability and, of course, supremacy, or to seek a correct interpretation of EU law in accordance with Article 267 of the treaty. So, one could say that Article 1 Paragraph 1 of Article 141c of the Constitution is a declaratory expression of two principles formulated in the case law of the European Court of Justice, the principle of equivalence and the principle of effectiveness. Both principles are embedded in the very foundations of the EU legal order and well established in the case law of the Court of Justice. These are procedural principles that bind regular and constitutional courts. Now we come to the meaning of Article 141c, paragraph 2 of the Constitution, and how can it be understood or interpreted. It can be understood as a norm that implicitly enables the direct effect and supremacy of EU law over Croatian law. These principles, which are embedded in the very foundations of EU law and constitute its legal order as original and autonomous. Therefore, this paragraph 2 must not be understood in a manner as a mere conflict rule, but as a constitutional acceptance of the fundamental principles on which EU law is based. It opens the Croatian legal system to the EU legal order and thus differentiates from the legal order of international law. It, among other things, represents the national legal expression of the principle of direct effect and supremacy of EU law over national law, but also contains other principles of EU law which are crystallized in the practice of the Court of Justice. For example, the obligation also lies within the Constitutional Court if it would find a breach of EU law and would be in doubt of its scope and or interpretation, to enter into dialogue with the Court of Justice in order to enable that court to enable its exclusive jurisdiction and provide a clear interpretation. However, although Croatia is a member state since 2013, the Constitutional Court did this only once in 2023. In a case in which the question whether local tax authorities are allowed to lower the census for taxation using the funds a student receives as subsidy for mobility for the purposes of education is a violation of EU law, the Court of Justice answered that such practice is a breach of EU law, so the Constitutional Court decided accordingly. However, there are situations in which, as practice has shown multiple times, provisions of EU law can be in direct contrast with the constitutional provisions of a member state. This has been seen in the case law of many constitutional courts of member states, such as Germany, Spain, Italy, French, Poland, Romania, Hungary, and Croatia. As it is known to all of you, it is the firm canon of Court of Justice, that EU law has supremacy even over the constitutions of member states. As all of you also know, there are some constitutional courts that agree, and of course some that disagree. Croatia's Constitutional Court is among of those constitutional courts that disagree, as was shown on the slide I mentioned that I will return to, because it said explicitly that the Constitution is above EU law. However, why it disagrees remains unclear or unknown. It only briefly stated Constitution is above EU law. This leaves many questions unanswered. First, does this mean that all constitutional provisions are above EU law? Many constitutional courts that defy Court of Justice on this matter clearly state this applies only on certain constitutional provisions of, so to say, of higher order, those that make the constitutional identity of a given member state. We lack such distinction in Croatia's Constitutional Court case law. Second, there is no clear explanation why the Constitutional Court finds that the principle of supremacy of EU law used on constitutions is not valid. There were no confrontations on this matter with the Court of Justice so far, so in reality, we do not know the stand of the Constitutional Court on this matter. So, to conclude, Croatia's Constitutional Court viewpoint regarding the Convention is clear. It was crafted through decades of implementation and admiration of the system built by the Convention and the Court of Human Rights. The Constitutional Court accepted all European courts' case law almost without any criticism. This can be explained, as I already said, with the enchantment the court had vis-à-vis the European Court and the Convention, and a pressing political need. However, when we look at EU law and the viewpoint of the Constitutional Court towards it, it is obvious that there is no enchantment, not towards the Court of Justice, nor towards EU law as a supranational legal order. I would almost go as far as to say that the Constitutional Court embraced the Convention, but only tolerates EU law. This notwithstanding the fact that Croatia is a member state since 2013, and the accession to the EU was the state's ultimate goal since 2000, and earlier but not so crystal clear. This is maybe a consequence of the fact that many feel EU law, in Croatia of course, as a necessary evil, and the fact that we as a state, or maybe better to say Lawyers' Guild, as a whole, do not really understand and really know EU law. The accession process was marked with how it was called a legislative tsunami, when a great deal of our legislature was changed and or recrafted. But this was done in haste, not explaining the need, nor presenting the benefits, if we do not take into account the EU dictates that argument. The mild resentment of EU law is then somewhat, I believe, translated to the Constitutional Court. However, the court will, in the future, be asked to position itself towards the principle of supremacy, and it will have to create its own argumentation, and it will have to frame the relation of the EU law towards the Constitution more elaborately than it has done so far. I hope I will tell you about it on some new conference, as I feel that I might have some inside information about that. Thank you for your attention.